Miller Center is one of the true treasures of the University of Virginia. I don't get over here enough, but I think it's I've never seen anything other than an outstanding program over here. I'm a school teacher, and one of the jobs of teachers is to make people think, and I'm going to shock and probably upset some of you, and I'll try not to leave until I've had a chance to at least defend myself if anybody's angry. Just for the record, the Mr. Hamilton quoted in the famous Supreme Court or famous Virginia case, the Civil War, was actually Alexander Hamilton in the Federalist Papers. It's a very famous description of presidential power. But let me start off. I'm a libertarian. I call myself a national security libertarian, which is to say I share the importance of civil liberties, but I also believe the government has important responsibilities for protecting the security of the people. And I agree the controversy, as many have said, raises serious concerns about law breaking, about government officials who believe they're above the law, and the like. But unlike most, I see this slightly differently. I think what we're talking about here is congressional law breaking. I worked in the Senate for 5 years during the mid-1970s. I was there when they passed FISA. I was the top lawyer in the White House in charge of enforcing FISA a few years later, and I wrote a 1,700-page doctoral dissertation on separation of national security powers with a special interest or emphasis on intelligence. These are not new issues. I have a couple of op-eds I meant to put out earlier.
I'm going to stick a little closer to ground level in my remarks, and I'm going to start by reading Amendment number 4 to the Constitution of the United States, the Bill of Rights, that deals with this issue. The right of the people, not U.S. citizens, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable, that's a pretty important word, unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. On this particular issue, I'm down in the weeds, as I say, because I recall having worked on the issue, much as Bob recalls it from the Congressional side, but in my case from the intelligence community side. And in a string of cases that came through the Supreme Court during that period of time, United States versus Katz, United States versus District Court called the Keith case, the Supreme Court made it clear that warrants would be required for domestic surveillance.
My colleagues here are replaying for you, if I may step back for a moment, the debate of the 1970s. And what I like to do, I'm not a lawyer, and I don't play one on TV, or try not to, is to step back and put into context both that debate and the current one. Because what you've heard today are very legitimate positions, and both positions backed by a great deal of scholarship and thoughtfulness. In the 1970s, what happened, I think, is the pressure that built in this country as a result of a long war exploded. The Cold War was a long war, and presidents made decisions at the beginning of that long war to do what Americans expected them to do, which was to defend them. But their decisions involved cutting corners. Not every advisor to the president, Republican or Democratic, had the confidence that Professor Turner has that unrestricted executive surveillance of domestic activities was constitutional. In fact, so many of them felt that it was probably illegal, that what they did was highly secret and wasn't even shared with Congress. I know this because I interviewed a number of them, and particularly those in the intelligence community. They felt what they were doing was unconstitutional, illegal, but they felt it was necessary because the United States faced this enormous threat from the Soviet Union.